Good morning, and welcome to today's session of Arbitrating IP and Tech Disputes in Hong Kong. My name is Eric Ng, and I am the Deputy Secretary General of the Hong Kong International Arbitration Center, or HKIAC. I am very proud to be joined today on this panel by very esteemed and experienced practitioners in IP and technical disputes. Firstly, let me start with some introductions. We're joined today, firstly, by Nicholas Wiegand, who is head of the Hong Kong and APAC International Arbitration offices of CMS. Mr. Wiegand specializes in international commercial and investment arbitration with a focus on corporate law, post-M&A disputes, joint ventures, commercial sales and distribution law, and IP matters, as well as the energy, pharmaceutical, automotive, construction, and infrastructure sectors. He is particularly experienced with arbitration in or in relation to Asia, specifically China, Korea, Japan, Singapore, Australia, Taiwan, Vietnam, Thailand, Indonesia, and other Southeast Asian jurisdictions. Alongside his work as counsel, Mr. Wiegand is also an experienced arbitrator with matters covering a wide range of jurisdictions, including Hong Kong, Japan, Singapore, Germany, Switzerland, and others. His cases are seated in most major arbitration hubs worldwide, and he's acted in over 30 arbitrations and has acted as emergency arbitrator, which will become useful when we start talking about other topics later on today. Our next speaker that I'd like to introduce is Sebastian Hughes, who is a barrister at Prince's Chambers in Hong Kong. Sebastian is a fellow of CIARB and a WIPO approved neutral. He is an arbitrator and mediator with HKIAC, WIPO, SCIA, SHAC, and AIAC. He is a domain name panelist with WIPO, Forum, HKIAC, ADN, DRC, and AIAC, and has rendered more than 800 domain name decisions in both English and Chinese. He's handled numerous intellectual property-related arbitrations as sole arbitrator, co-arbitrator, and counsel. Sebastian was admitted to practice as a solicitor in Victoria, Australia in 1998, and in Hong Kong in 2003. And prior to being called to the bar, he was a partner in an international law firm. Sebastian is also a fluent speaker in Putonghua. Finally, I'm joined by Ms. Look. Teresa Look is a partner at Deakins in the IP Commercial and Litigation Practice Group. Teresa is a Hong Kong qualified solicitor specializing in intellectual property enforcement and commercialization. She also holds an honors bachelor's degree in life sciences from the University of Toronto, specializing in human biology and nutritional science. Her practice covers IP protection and enforcement in Hong Kong in the areas of patents, trademark, registered designs, passing off copyright, trade secrets, and confidential information. And she's one of the few lawyers in Hong Kong specializing in both patent litigation and arbitration. So that is our panel for today. And I'd like to start off by first talking about intellectual property arbitration in Hong Kong. Now, intellectual property arbitration brings with it unique characteristics and unique reasons for why it has only recently come into the limelight in terms of international arbitration. And perhaps I'd like to start today with a discussion with Teresa in relation to why IP arbitration has unique arbitrability considerations and why it is arbitrable in Hong Kong and why Hong Kong is a well-suited seat for arbitrations dealing with IP matters. Teresa, over to you.
All right, thanks, Eric. So I'll start by talking about the arbitrability of IP issues, and a very quick overview of today's roadmap is I'll first talk about whether the arbitrability of IP disputes is universal, and if not, then why. Then we'll look into the relevant legislative reforms in Hong Kong with respect to arbitrating IP in Hong Kong and other developments relating to arbitration funding that will be welcomed by IP owners. And lastly, we'll wrap up with some practical tips to overcome arbitrability issues with a specific focus on how arbitration clauses can be drafted in this regard. So arbitrability of IP issues, what's the big deal? Why do we have to consider the arbitrability of our IP issues? So the issue of arbitrability of a subject matter is directly relevant to the recognition and enforcement of any arbitral award that would result. So as most of us know that under the New York Convention, recognition and enforcement of an arbitral award in another contracting state may be refused if the subject matter arbitrated is not capable of settlement by arbitration under the law of the enforcing country, or if the recognition or enforcement of the award would be contrary to public policy at the enforcing country. So similarly in Hong Kong, under the Hong Kong Arbitration Ordinance, it also provides that enforcement of an arbitral award may be refused if the subject matter is not arbitrable or if the award is in conflict with public policy. So this is why arbitrability is an important issue, because if the subject matter is not arbitrable, then the resulting award cannot be enforced and you might be left with an empty judgment. So are all IP disputes universally arbitrable? And unfortunately, the answer is no. So the position differs depending on jurisdiction. And even within the same jurisdiction, the position also differs between one IP to another. So there are certain public policy and subject matter issues that arise, particularly in relation to registered IP rights. So registered IP rights are often a result of governmental examination and grant. And the registration dictates the relationship between the owner as against third parties in relation to the registered IP. So if there are any changes to the ownership, validity, or scope of any registered IP right, then this will affect how third party can deal in the IP, whether consent is required to deal with it. And such changes will also affect the information on the IP register. So the argument is that issues such as validity, ownership, and the scope of registered IP should only be a matter within the purview of governmental authorities and the court, as these issues affect third parties' rights. So the issue of arbitrating IP is that arbitration is a private and consensual process where the power of the tribunal is determined by the parties' agreement. But very often in IP disputes, you will have the validity and scope of a registered IP challenged. And this is especially so for tech disputes where patents are involved. So very often, the tribunal would be required to rule on these issues of validity, scope, ownership. And this is where the conflict arises, because these issues, some jurisdictions think that they should fall within the exclusive domains of local courts and authorities, and it's not the domain of the arbitral tribunals whose powers are derived privately from the parties. So this is why some jurisdictions view that arbitration is unsuitable to resolve matters such as issues on validity and scope of an IP right that would affect third parties' rights. But on the other hand, this is not to say that all types of IP disputes will face the arbitrability issue. Issues such as breach of contract claims relating to IP rights or license disputes that do not involve validity of the underlying IP, these are generally recognized in many jurisdictions as arbitrable. So what's the position in Hong Kong? So in 2017, Hong Kong passed an amendment to the Arbitration Ordinance, which came into effect in January 2018. And the amendment is to confirm that intellectual property rights is arbitrable between the parties to the IPR dispute. And secondly, arbitral award concerning an IP dispute is not against public policy. So under the amendments, the arbitrability includes disputes over IP subsistence, scope, validity, ownership, infringement, as well as other aspects such as disputes over IPR transactions and royalties. And also, you can arbitrate IPR of whatever nature, regardless of whether or not the IPR is registered or not, and whether it's subsisting in Hong Kong or elsewhere. So this clarification is significant, particularly from the tech disputes perspective, because tech disputes often involve patents, and patent disputes are often multi-jurisdictional. So parties can agree to use arbitration to resolve multi-jurisdictional infringement disputes in one single proceeding with one set of attorneys, and also possibly with one set of applicable laws, even if you have different patents involved in various jurisdictions, which will greatly reduce time and cost in this aspect. So determining multi-jurisdictional infringement in one proceeding will also eliminate the risk of having conflicting decisions if there were to be parallel patent infringement proceedings in many jurisdictions. And it's actually not uncommon for there to be conflicting decisions in various jurisdictions. So to this, Hong Kong is actually very well placed as a jurisdiction to determine multi-jurisdictional patent disputes, especially against mainland Chinese respondents. And this is because, as we all know, that mainland China is the world's top manufacturing hub. And for tax and various logistical reasons, products manufactured in mainland for overseas markets, such as the US or the Europe, they're often actually first transported to Hong Kong before being sent by air to the overseas market. And I understand this is partly due to tax and also the efficiency, the relative efficiency and the reliability of the Hong Kong airport. So mainland China manufacturers like doing that when they have to send goods to overseas markets. So even if in that case, then even if the products are not intended for the Hong Kong market or not sold in Hong Kong, then the Hong Kong patent law can also catch these infringing products on the basis of it being imported or stocked in Hong Kong if there's a registered patent in Hong Kong. In fact, I have very recently assisted a US-based biotech client from preventing a mainland Chinese infringer from using Hong Kong as a transportation hub to ship products to overseas markets. So we were successfully able to obtain interim relief for the US-based client. And this successfully curtailed the supply of such products from mainland China to the overseas market. So therefore, this clarification in the arbitration ordinance with respect to the arbitrability of various types of IP rights, whether within Hong Kong or overseas, is good news because it means that any types of arbitration, any types of intellectual property can be arbitrated in Hong Kong. And that does make Hong Kong a favorable jurisdiction to resolve patent infringements and tax disputes, given that Hong Kong is located at the doorstep of mainland China. And there are a lot of mainland Chinese companies with presence here, and also due to various legal regimes that Hong Kong has with mainland Chinese, which I understand that my fellow speakers will share with us later on today in this webinar. So if there are infringements in multiple jurisdictions, including Hong Kong and overseas, then the parties can agree to resolve the multi-jurisdictional patent dispute via arbitrating in Hong Kong in one single set of proceedings, which makes it a lot more convenient. And as with a lot of jurisdictions, the arbitration ordinance also confirms that arbitral awards on IP dispute is not binding on licensees who are not a party to the arbitration, nor are they binding on the IP registrar. So I understand this position is the same in a lot of jurisdictions, such as the US, where the arbitral award would only bind between the parties and not against third parties. So in the same year, in 2017, Hong Kong also passed an amendment to the ordinance to clarify that third-party funding of arbitration is not prohibited by common law of maintenance and charity. So these amendments came into effect in February 2019. And third-party funders are now expressly allowed to provide arbitration funding in Hong Kong. And the agreement may be structured so that the funder will receive a financial benefit if the arbitration is successful within the meaning as defined in the funding agreement. However, relevant sections of the third-party funding provisions have excluded lawyers acting for parties in arbitration as third parties funders, and this issue is addressed very recently in the amendments to the arbitration ordinance, which came into force in December 2022. So these very recent amendments expressly allows for lawyers to have outcome-related fee structures agreements with their clients. So very briefly, there are three types of agreements that are allowed. Firstly, it's conditional fee agreement, where it's either no win, no fee, where the client only pays the lawyer's fee if an agreed successful outcome is achieved, or it's no win, low fee, where the client pays lawyers at a reduced rate if the agreed successful outcome is not achieved. But if they do win and achieve the successful outcome, then they will have to pay, in addition, a success fee. The second type of arrangement allowed is a damages-based agreement, where the client only pays its lawyers a sum calculated by reference to the financial benefit that's obtained in the proceedings, such as damages or an account of profits. So the third arrangement allowed is hybrid damages-based agreement, where the client pays its lawyers a sum calculated by reference to the financial benefit obtained, as well as paying legal fees, which may or may not be discounted. So these legislative reforms with regards to third-party funding and the outcome-related fee structure arrangements are good news for IP owners, as we all know that the cost of enforcement is often one of the major issues, if not the the only issue that deters or prevents a party from taking action, even if there's clearly a strong case. So rights owners can now make use of the flexibility of these cost arrangements to access justice for meritorious claims and to share any risks associated with costs with their third parties and their lawyers. So how do you overcome the risks with non-arbitrability of IP issues? Most importantly, always, is to verify the laws and jurisdiction of enforcement to see whether arbitral awards concerning IP disputes are enforceable in that jurisdiction, and if so, to what extent? Because some jurisdiction allow, like Hong Kong, allow arbitrability for both infringement and validity, whereas some other jurisdiction only allow for certain aspects of the intellectual property, like infringement, to be arbitrated, but not other aspects such as validity. So once the legal position has been determined, then it's essential to draft the arbitration clause carefully based on the position. So you first need to define the power of the tribunal, that their award will bind parties to the arbitration only and not anyone else, which makes it clear that it will be a private agreement in order to be in line with the public policy argument that the award from arbitration should not affect third parties and the IP register. And then you need to state clear that the tribunal is not to make any decisions on validity, so that even if they are of the view that the IP is invalid, there will not be any invalidation or revocation effect on the of the registered IP on the IP register. So this only provides tribunal with the power to consider and render an opinion to the parties so far as required to decide on the IP disputes between the parties, and try to avoid using wording such as rendering a decision or rendering a determination. So the clause will specify that the tribunal is to render an award on this basis, that they give a view, and state that the parties agree to be bound by such an award, which shall be binding and final between the parties. So if the jurisdiction allows enforcement of all IP disputes, then you may not need to go so far. Or if there's only partial types of IP disputes that can be arbitrated, such as infringement but not invalidity, then you may say that the tribunal can render a decision on infringement, but only an opinion or a view on validity. So here is one example of an arbitration clause from one of the cases that I did where deacons represented the claimant. So to give a quick background, the claimant originally sued the mainland Chinese respondents at the Hong Kong court under breach of confidence relating to trade secrets and confidential information. But then the parties settled the court proceedings where the claimant agreed to discontinue the action in the Hong Kong court in return for the mainland Chinese respondents agreeing not to use or infringe the claimant's trade secrets and patented technologies. So in the settlement agreement, the parties have agreed on this arbitration clause that we have on screen here. So the clause goes, any dispute, controversy, difference, or claim arising out of or relating to this agreement, or any non-contractual disputes arising out of or relating to it, including the views on the use or infringement of patented technologies and their validity, shall be referred to and finally resolved by arbitration administered by the HKIAC under the HKIAC Administration Arbitration Rules Enforcement Notice of Arbitration submitted. So this is quite standard. And then it goes that, however, the arbitral tribunal's views, instead of determination, on the dispute in question shall only be applicable between the parties to this agreement, and they shall not be applicable to a person who is not a party. So this makes clear that whatever the tribunal's views are only binds the party themselves. And then if the arbitral tribunal has to decide on the validity of any patents, then this clause provides that the arbitral tribunal has the power to consider and express its views on such issues. So this is so that the arbitration, from the arbitration jurisdiction point of view, the tribunal still has power to consider these issues. However, the clause then goes on to state that the arbitral tribunal has no powers to declare whether the patents are valid or enforceable. But that said, the tribunal should issue an opinion on the question of validity and state its reasons, though such opinion or reason shall not be regarded as a declaration to the validity or enforceability of the patents. So the arbitral decision shall specify any particular actions that each party needs to take, and the arbitral decision shall be final, effective, and binding on the relevant parties. So this example encapsulates the tips that we talked about earlier to overcoming the risk of non-arbitrability of IP issues. And hopefully, if the arbitration clause states clearly that the tribunal has no powers to declare on invalidity and can only render an opinion or view on this issue that only binds the parties, then the resulting award will not be regarded as against public policy in the enforcing state. Yeah, so this is what I have to share with you guys today.
Thanks a lot, Teresa. I think it's also important to note from the amendments to the arbitration ordinance to see how frequent the amendments have been into the Hong Kong arbitration ordinance. You see amendments in 2017, both in relation to IP as well as third-party funding, and then subsequent amendments in 2022 to allow for outcome-related fee schemes. I mean, it shows that Hong Kong is keeping the arbitration ordinance, or at least the arbitration law of the seat, well updated and frequently updated to sort of keep up with the times. So thanks a lot, Teresa, for that information, for that presentation information. I'm sure that was very helpful for a lot of people who may not necessarily be clear on sort of the unique aspects of IP arbitration, particularly in various different seats around the world. The considerations for IP disputes extend a little bit beyond just issues of the seat. There are issues in relation to IP arbitration that you may not necessarily see in other sort of commercial industries. And I'm very glad to have two experienced counsel and arbitrators with me today, and Sebastian and Nicholas. When parties are going into an IP dispute, are there any sort of unique considerations that they have to keep in mind when they're handling their dispute? And in particular, I'm thinking perhaps along the lines of preserving confidentiality. And maybe we could start with Sebastian, because as I understand that you've done some cases under HKIAC's auspices in relation to IP.
Yes, thank you, Eric. Certainly, I think perhaps to follow on from Teresa's presentation, before we address confidentiality issues. What's been interesting in Hong Kong is that following the amendment of the arbitration ordinance in 2018, we have seen HKIAC set up a panel of IP specialist arbitrators. And before the amendments, whilst there were arbitration disputes relating to IP, they tended to be largely contractual, largely relating to licensing agreements. What we do have now is, as highlighted by Teresa, confirmation that in Hong Kong, any dispute relating to IP, including disputes relating to infringement, subsistence, validity, scope, and duration, are capable of arbitration in Hong Kong. So I think what that has meant is that we've seen an increase in IP disputes in this jurisdiction that go to arbitration. And I think there are a number of benefits for IP owners when considering whether to take the arbitration route as opposed to the litigation route. Firstly, confidentiality, of course, may well be a very valuable consideration. Of course, the arbitration process itself, as we all know, is confidential. And under the Hong Kong rules, the tribunal has a very broad discretion in terms of how it will conduct the proceedings. And that would include, for example, attorney eyes only orders that can be either implemented by agreement of the parties or under the tribunal's broad discretion. So I think that's something, particularly in the trade secrets and patent field, that will be of potential interest to IP owners. What else perhaps makes arbitration more suitable? The parties, of course, have the ability to choose the tribunal. And I think that's very important in the IP field. Whilst in Hong Kong we have an IP list in the courts, we do have an IP specialist judge. In the IP field, of course, it's very important, I think, for the parties to be able to consider appointing a tribunal with particular expertise in relation to that that area of technology or IP. So, for example, I had a case administered in Hong Kong which related to a tech licensing dispute with underlying patent rights, where there was a 3-member tribunal appointed. The claimant was based in the US, the respondent in China. The parties had agreed in the arbitration clause that the presiding arbitrator had to be admitted in the US. It was governed by California law. The seat was in Hong Kong, and it was governed by the HKIAC 2018 rules. So in that situation, the parties were able to appoint a Canadian national admitted practice in New York as the presiding tribunal, a US attorney who'd spent time in Hong Kong and China, but was based in California as one of the party appointees, and myself as the other appointee. And 2 of the 3 tribunals had Chinese language ability skills as well. And I think all 3 of us had the necessary expertise in relation to that particular technology. So I guess that's an example where I think it was helpful for both parties to be able to take advantage of the regime that we have here in Hong Kong. I guess a couple of other points that would make arbitration attractive potentially to parties in Hong Kong. We do have the ability to obtain interim measures, essentially injunctive relief or restraining orders. In fact, they can be applied for even before the constitution of the tribunal under our rules. We also have an emergency arbitrator procedure, whereby the emergency arbitrator must be appointed within 24 hours, and the emergency award has to be issued within 14 days. That's another very useful tool for arbitration in Hong Kong. Also, I think we're seeing increasingly parties availing themselves of the expedited procedure under our rules, whereby the award is to be issued within 60 days, and that can be very attractive to parties in not just IP disputes, but commercial disputes in general. I should add that the interim measures under our rules really govern all of the traditional injunctions that you would seek in an IP case. So that would include injunctions, restraining orders, orders for freezing bank accounts, or all of those remedies are available. Also, we have, happily in Hong Kong, the court here is very supportive of arbitration, very supportive of party autonomy, and very willing to confirm and implement awards and decisions made by tribunals governed by Hong Kong law. So all in all, it's a pretty good regime here. And I think Eric might have some statistics in terms of how IP disputes have continued to grow since 2018. And perhaps one further thing I might add is that I read with interest Teresa's suggested arbitration clause relating to IP. And that may well be appealing to parties involved in arbitration of IP or tech disputes. But I think what is interesting is that it's clear under Hong Kong law that tribunals do have the ability to determine questions of validity, scope, duration of IP rights. And I think that will come, that's going to increase in Hong Kong. And I would expect the courts and certainly the registrar of the various IP registers here in Hong Kong would also be very supportive of that as well.
Thanks a lot, Sebastian. And just to, thanks for the foreshadowing in respect to the statistics. And you are right, there have been a rising number of IP disputes in Hong Kong over the past several years. I think, in fact, we're seeing new records being set every year. I think in 2020, we already had a record number of cases. I think in 2022, we've recorded another record number of cases with 344 administered arbitration disputes. IP arbitrations as a subset of that is continuing to rise, but more importantly, I think what's important to see in terms of HKIAC numbers is that we've seen the transition from Again, as you mentioned, royalty disputes, which would generally be arbitrable, to more decisions in relation to infringement, more decisions in relation to subsistence and validity of IP rights. And we're seeing that sort of come in around 2019 to 2021. We're still, it's still not a huge portion of HKIAC statistics. I think we're probably still in the single to double digits here in relation to the number of IP arbitrations. But when we look at the statistics, what we can see is we're seeing a shift away from what was originally around 70% royalty disputes to now pretty even between royalty disputes and validity and infringement matters in relation to IP. Now, Sebastian's also mentioned the IP list of arbitrators, and that is something that we instituted in response to the growing number of IP arbitrations and in relation to the amendments to the arbitration ordinance. The IP list of arbitrators have been vetted specifically based on their experience in intellectual property disputes. As of to date, we have 51 members on that list. Those members come from 14 different jurisdictions and speak 19 different languages, which shows just the amount of diversity that you have in relation to your choices of IP arbitrators for your disputes, which Sebastian has mentioned is something which is very important because although we're talking about IP, it can vary from field to field, from industry to industry, and from business to business. So having a variety of potential arbitrators with a variety of different experience is something which is very important for your IP dispute. While we're on the subject of HKIAC in Hong Kong and interim measures, it's probably not entirely well known to the audience at the moment that Hong Kong has actually concluded a specific arrangement with mainland China in relation to the enforcement and the grant of interim measures in mainland courts. As of right now, Hong Kong is one of only 2 seats in the world, the other being Macau, where you can get an interim measure from a mainland Chinese court for a foreign seated arbitration, i.e., if your arbitration is seated in Hong Kong, you can get interim measures for preservation of assets, preservation of evidence, or preservation of conduct from a mainland Chinese court. And that covers most of the types of interim measures that Sebastian has just mentioned. If your arbitration is seated anywhere else in the world, the mainland Chinese court will not grant you an interim measure because they will consider that to be a foreign seated arbitration. So a Hong Kong seated arbitration at the moment grants sort of a best of both worlds, where you have a modern, international set of rules, an up-to-date arbitration ordinance, but also the ability to gain interim measures in a mainland Chinese court. And if you're dealing with a mainland Chinese party, this directly goes to your ability to recover assets from an award or to enforce your award. Because given the current length of time for arbitration, by the time that you get to enforcement, if you don't have an interim measure in place, there is a risk that you won't be able to enforce your award. There won't be assets left. And so being able to get these interim measures has essentially been a game changer for a lot of parties. And that's been proven out in terms of the statistics. To date, we've seen 89 applications under the interim measures arrangement between Hong Kong and mainland China for requested preservation of assets over 23.7 billion RMB. That's about $3.5 billion US. We've seen 66 orders from mainland Chinese orders granting these interim measures, preserving assets of about 15.6 billion RMB, or about $2.3 billion US. That's all money that likely would have dissipated by the time you get to the award stage. And so we're seeing the effect and the success of the interim measures arrangement in practice, in real life, in real time today. Sebastian's also mentioned the EA and the EP rules. There's not much else to talk about in terms of EA. If under the HKIAC 2018 rules for EA, we will grant interim measures, we will appoint an emergency arbitrator within 24 hours of the request. In relation to expedited procedure, arbitrators who are conducting matters under the expedited procedure are obligated to issue an award within 6 months of the transmission of the case file to it. And in our cost and duration report, which was published in 2021, we've seen most arbitrators have adhered to those EP and expedited procedure timelines. Now, before we get to Nicholas in relation to his experience as an arbitrator, I know, Sebastian, what about differences between arbitration and litigation in relation to IP? I mean, is there anything specific in relation to timing of arbitration versus litigation?
Yes, I think it's fair to say that certainly in Hong Kong, we're finding that arbitration tends to be concluded a lot quicker than court litigation. And even parties that don't avail themselves of the expedited procedure will usually find that the process is a lot quicker. I think for an IP litigation dispute, from commencement through to trial, through to receipt of the judgment, you can be looking at several years. Whereas IP arbitration, I think, can usually be concluded a lot quicker than court litigation. So I think that's another important consideration for parties when they're considering which route they might want to adopt for resolution of IP disputes.
It's great to hear, and I think that's very important to keep in mind is also the time frame when you need to have your dispute resolved. Nicholas, let's get your views on this in relation to as an arbitrator. I think you've dealt with matters under the HKIAC rules as well as others, and in your experience in relation to IP disputes, has there been anything unique that's arisen? Any sort of considerations that parties or counsel should have in mind? And perhaps even comment on some of the things mentioned by Sebastian in relation to the dreaded sometimes AEO or attorney's eyes only order.
Yeah, absolutely. Thanks very much. And thanks, Teresa, and Sebastian. It's been very interesting. I think the first comment I would make is that what a relief that Hong Kong actually has set matters straight, and we know where we are. There's clarity, both in terms of arbitrability, in terms of outcome-related fee arrangements, third-party funding. So Hong Kong has done a really good job in getting those things straightened out and clear. I remember, I think it was 10, 11 years ago when INTA was held in Hong Kong, and I was sitting on a panel discussing more or less the same things, arbitrability of IP disputes in Hong Kong. It was a much more controversial discussion than we're having today when it comes to what is possible and what is not possible, and the risk associated with it. So quite a lot has happened since. And when you look at how other jurisdictions have fared since then, not much has happened in other jurisdictions. I mean, I'm originally from Germany. Our IP arbitration in Germany is still a very controversial issue, how far it extends. I mean, at the time, back then and still today, kind of Switzerland was kind of stood in the limelight as being very friendly, arbitration friendly when it comes to IP disputes. So that was at the time, I remember on that panel 10, 11 years ago, Switzerland was kind of the example of this is how you can do it. And I'm very glad to see that Hong Kong has basically recognized that this is an important area where arbitration should evolve into. So that's really good to see. I also wanted to comment on one other thing on the drafting of the arbitration clause, and that does relate to my experience as an arbitrator, because you can see some really nasty things when it comes to parties trying to be careful not to include IP issues in their arbitration and try to carve out IP rights issues even already in the arbitration clause. That's obviously a very, very difficult thing to do if it's not drafted very carefully, and it can go terribly wrong. Because as we all know, I mean, commercial disputes, IP disputes, there's such an overlap and such a gray area where does one start and where does the other one. And so I think there's some real big traps here for parties trying to say, oh yeah, well, yes, our relationship involves IP issues. We only want to arbitrate the commercial side's IP rights, especially when you just generically exclude IP right disputes. I think that can go terribly wrong. There's this famous case the Swiss company called Myriad versus Oracle, and which was decided in California courts, where the Swiss company Myriad actually moved to compel arbitration based on an arbitration clause contained in the license agreement, which excluded, as I said, the generic term IP right disputes. The district court actually granted that motion to compel with respect to the breach of contract claim, so that they had to go to arbitration. But the Court of Appeal, of course, then later reversed that, because they said you've agreed to the UNCITRAL rules, and in the UNCITRAL rules, the only competent body to decide on the competence is the arbitral tribunal. So they had to go back and eventually spend over 2 years only litigating about the fact who's competent to decide on whether or not IP rights can be argued before the California courts, or had to go to arbitration. So it's a really treacherous path when it comes to drafting arbitration clauses that try to address IP rights disputes, and if they don't do it properly. Again, I'm glad to see that when it comes to Hong Kong, there's no need to try to carve out things, except, of course, if you think about the enforcement. And Teresa, you're absolutely right. The enforcement of resulting awards in the respective jurisdictions, I think that is a key point you always need to think about when it comes to that. Now, the confidentiality issue addressed by Sebastian, of course, is one of the key issues, and again, there's lots of things that can go extremely wrong. Of course, it's one of the huge advantages of arbitration, especially when it comes to IP disputes, that you have the confidentiality protection in jurisdictions like Hong Kong. Not everywhere. I mean, that's something people tend to forget as well. If you have not an HKIAC arbitration and not in Hong Kong, but let's say an ICC arbitration in a European jurisdiction, is likely not going to be confidential unless the parties agree to confidentiality. That's a very important aspect to remember. And when it comes to agreeing to such confidentiality, again, same caveat or same warning rather, as with trying to exclude generic terms mentioning generic terms like IP rights disputes, just trying to agree on confidentiality issues. Either everything's confidential, or you need to be really very specific of what the parties want to be made confidential at the very outset of the arbitration. So a very clear scope of which information that is being exchanged in the arbitration, unless you want the entire arbitration to be confidential, is absolutely key. Because then otherwise you are at risk of derailing the entire proceedings when it comes to exchange of certain information, when it's not clear at the outset which of what the scope of confidentiality obligations is. And I'll give you an example. I've seen too many cases, unfortunately, as an arbitrator, where this sometimes wasn't done properly by the parties at the outset, and where things usually then go terribly wrong is in document production. Because the proceedings start, everyone thinks, oh, it's all fine, and you only exhibit the parties only exhibit the documents they think they can exhibit and which are unproblematic, or they designate them as confidential or not. But then you come to document production, where typically in IP rights disputes, it can be very voluminous and also very, very confidential, because that's usually the parts that you don't want the other side, or at least the other side's lawyers, perhaps, but definitely not your opponent, and definitely not someone else to see. So what can happen is, when you get to the document production phase and you do not have either a complete confidentiality or a very specific confidentiality agreements at the outset, including within the arbitration, so which documents are okay for the other side to see, for the tribunal to see, or only for counsel to see. If that's not defined at the outset, you may then run into hundreds of documents being exchanged during the document production phase, or rather not being exchanged, but held back, and then countless applications being filed with the tribunal saying, oh, no, this doesn't work because this is our trade secret, this is et cetera, and then you end up, and I've seen it happen with endless lists of hundreds of documents where disputes arise whether or not certain documents will be designated attorney's eyes only, or should go into a confidentiality club, or should not be disclosed at all. So this can really lead to arbitrations that are, you have a schedule or timetable which will bring you to an award in 12 months. But if this intervenes and it's not done carefully at the outset, or even before the arbitration arises by the parties, this can then lead to delays of months, if not years, until these disputes over confidentiality and how certain documents have to be treated are eventually resolved. And it's particularly unfair to the tribunal, I have to say, sometimes, because it's a problem of the parties making, to be quite honest, if they do not think of this before. But the tribunal then, of course, it's easy to blame the tribunal that things take long, but it's very, very difficult sometimes for a tribunal to determine whether out of hundreds of documents, certain paragraphs are attorney's eyes only, or should not be disclosed at all, or should be, as I said, subject to a confidentiality club, where only certain appointed people are members. It's a very, very tricky job for the tribunal to do. And it's, as I said, something that can be avoided if it's done carefully before. So my encouragement to any parties that are about to engage in an IP rights dispute is to think about that before, because otherwise they'll be disappointed as well that proceedings might take much longer than they think.
Yeah, I think that's very keen observation, Nicholas. I think at the end of the day, things like an AEO order or a confidentiality club, these are tools for the arbitrators and the parties to use in order to, maintain the efficiency. But like any tool, if it's used incorrectly, if it's used without regard to its effects, then it doesn't have the desired impact. And I think everyone has seen disputes where these sorts of orders have both effectively managed to resolve key issues, and in certain cases, as you said, completely derail matters, whether it's for counsels or for arbitrators. So
absolutely. And I'm not saying that I've just mentioned the risks now. Of course, I think these measures, as I said, they're very effective tools, and they should be used, especially obviously in IP rights disputes. They are very valuable tools and should actively be used. But as you said, they need to be used right, in order to be effective.
Yeah, absolutely. So we've seen basically now, as has been flagged both by Sebastian and Nicholas, a maturing landscape of IP arbitration, where the tools are now in place, and the structure is in place for the sudden growth or large growth in IP arbitrations. And we're seeing a lot of that now, with a lot more in terms of tech transfer agreements, a lot more that are going to arbitration, a lot more rights where IP rights are bundled into sort of a larger sort of contract. So we're seeing sort of a maturing landscape in relation to IP arbitration, at least in Hong Kong. What we're sort of seeing now in terms of Greenfield, and this sort of is changing tact just a little bit, because this is about IP and tech arbitrations in Hong Kong, has been sort of the sudden shift in landscape for technology disputes. And in particular, I think we saw this in particular in a special regard in 2022. Now, for those of you who have worked with HKIAC or are familiar with HKIAC over the past 35 years or so, you would understand probably the core of our arbitration disputes that HKIAC has dealt with has traditionally been commercial sale of goods. That makes sense, with Hong Kong being a center for trade and a trade hub, that a lot of the disputes that go to arbitration in Hong Kong and HKIAC arise from the sale of goods and commercial disputes. In 2022, for the first time in quite a long time, we saw commercial sale of goods disputes being overtaken as the majority of or the largest portion of HKIAC's disputes. And in 2022, 36.9% of HKIAC's disputes arose from banking or financial disputes. Now, that's because, in particular, one of the categories or subcategories of banking and financial disputes was fintech and crypto. And we saw a sudden spike of crypto and fintech cases in 2022, probably arising from crypto winter and the collapse of various other exchanges and other tokens around the world. But a lot of those disputes came through Hong Kong and used HKIAC rules. Now, why is that? Why are we seeing an increasing number of cryptocurrency and technology disputes coming through Hong Kong? Well, part of it is the structure of the Hong Kong Arbitration Ordinance and the interim measures arrangement, as you have noted. Part of it is also due to the suitability of HKIAC's rules. Where you have a volatile digital asset, efficiency in terms of time to resolve the dispute is of paramount importance. And HKIAC has been one of the most efficient organizations in relation to managing arbitrations since the 2018 rules came out. Now, that's due to some of the issues that we've discussed earlier in relation to expedited procedure. Being able to have your dispute resolved within 6 months of the constitution of the arbitral tribunal is a key driver in maintaining efficiency and making sure that you're able to get your award within a timely manner. The ability to gain emergency arbitrators within 24 hours of your request has been used in cryptocurrency disputes in order to ensure that interim orders can be granted. And the use of the interim measures arrangement, again, with mainland Chinese parties, helps ensure the enforceability of assets. So I would just raise a question now to the panel in general, is when we start looking now at technology disputes, are we in a position now where where Hong Kong and HKIAC is well suited for technology disputes, or is there further work to be done? Looking forward, are there things that we need to do as a seat or as an institution where we can better accommodate for a changing landscape, a changing type of dispute, where assets are no longer physical, but maybe digital? And I would open this up for anybody on the panel.
I'll just throw something in to start with, and hope we can discuss on it. I think the key issue when it comes to these tech disputes will be speed. Disputes need to be resolved very quickly, especially when it comes to, as you mentioned, the cryptocurrency disputes. It's such a volatile asset. If you start your dispute today, your whatever the Bitcoin or whatever you're fighting about might be worth a couple $1 million, and next if you get your award in 2 years, it might be a fraction of it. Or even a few weeks later. So it's such a volatile and changing landscape that none of us really knows. There's no experience with it. It's new to most players, including in particular to the lawyers. Lawyers don't tend to react very quickly to new technology trends, but in this case, I think it has arbitration has adapted relatively quickly in that we fortunately already have the tools to deal with that. I mean, we have expedited procedures, we have emergency arbitration procedures, not in Hong Kong, but also elsewhere, to be fair, so that the tools to address disputes that can't go on for 2-3 years simply because the asset you might be fighting over, whether or not you're preserved through an interim injunction or not. I mean, if it's not worth anything anymore, it's not interesting, right? So yeah, I think my take is if you can provide speed and efficient resolution, I think that's going to be the key for any institution and arbitration hub in the future for these tech disputes.
Yes, I also want to add on to the volatility aspect of these crypto by giving an example of a recent case that I did that shows that potentially if the parties had used HKIAC's expedited procedure, then it would be, very useful. So I recently acted for a local media company for licensing its IP to a metaverse gaming platform. So then that platform can sell NFTs using our client's IP. And the platform was supposed to pay, royalties to our client based on the cryptocurrency that the platform has owned. But for some reason, that time that they were supposed to pay was around mid-2021. But then at that time, the crypto was actually being very volatile and skyrocketing. So for some reason, they didn't pay at the time that they were supposed to pay. And then when the time that they accounted royalties to our client, the crypto had already skyrocketed and quintupled to more than $5 USD per token, when previously when they were supposed to pay us, it was less than $1 per token. So obviously the platform at that time then didn't pay out to our client because the crypto was so high. And then for the bulk of year 2022, the parties was just in negotiation for the entire time, during which then the crypto dropped back down to less than $1 USD per token. So even though the parties ultimately settled at a midpoint royalty rate, but then this is an example that I wish to share where if the parties had an arbitration agreement and make use of the expedited procedure, then it could come in very handy, as the dispute could have been resolved in the middle of 2022 where the crypto had not dropped that significantly. But whereas if you go to courts in this case, then it wouldn't really help the parties because the court procedure would take years. And this is not a case where they can go to court and get interim interlocutory preliminary injunction, because or in a dispute of royalties, sometimes it's just all about money and there might not be irreparable harm that could result. So yeah, in this case, the expedited procedure would definitely ease the process of the parties' settlement, which could help the claiming party if the relevant currency, like crypto, are depreciating very quickly.
I think I might add, if I may, in terms of public policy, I think it goes hand in hand with the Hong Kong government's stated support of crypto implementation of licensed trading. And we do, from an arbitration perspective, I think hand in hand with the rising cases that Eric was discussing, we do have a pool of arbitrators here that have experience in that field.
Yeah, thanks, Sebastian. And I think that's also key. Again, the dispute's only going to be as good as who you have deciding it. And one of the key factors of arbitration is you get to choose who decides it. And going back all the way to the start of arbitration, you pick the one that has knowledge of your industry, usually, who has knowledge of cryptocurrency, who has knowledge of technology, and is able to deal with it. And I think we have, at least in our list and panels of arbitrators and in our lists of specialist lists of IP arbitrators, a good number of arbitrators who have demonstrated experience with sort of cryptocurrency and technology disputes.
I think generally it's I mean, from Bay Area to Bay Area or to Greater Bay Area, I think the amount of arbitrators in Hong Kong that are, let's say, able and available to hear and capably decide very technology-related disputes is high, simply because it's a high-tech area, much like the Silicon Valley over here in California. It's people in Hong Kong and whoever, I mean, this is in California Arbitration Week now, whoever's been to Hong Kong will see some similarities, that it's a very tech heavy place, and that is reflected also in the legal industry. So I think you do get the people, and also not just the arbitrators, but also the lawyers that are knowledgeable in the industries, and that also, when it comes to China, also knowledgeable what it means, how to resolve disputes that relate to China. And cryptocurrency in China is an issue in itself, because cryptocurrencies in China are not permissible, not legal. So you also have to bear that in mind when it comes to a cryptocurrency dispute, that if you want to enforce that award in China, you can't have it formulated or brought in a way that it is basically exchanging cryptocurrency into currencies. So that's something else you need to bear in mind, right? And I think the people in Hong Kong have that necessary experience, both arbitrators and counsel, that to deal with these very specific circumstances of the market.
Thanks a lot, Nicholas, for the observation, and absolutely agreed on that. Unfortunately, we're getting close to our time limits for this session, so perhaps I could ask if there's any sort of final sort of comments or observations in relation to the topic that we've discussed today, in relation to anything that the parties or either the parties or the council should keep in mind when considering IP disputes or technology disputes for Hong Kong. Perhaps we start with Teresa.
Yeah, I think it's really great that as you can see from the amendment ordinance to the arbitration ordinance, that there are a lot of various safeguards and options that are now given to the arbitrating parties. And which could also help tech disputes, like the third-party funding and everything that can help IP owners in thinking of their different cost options that they can have. So I think that's very, very good step forward that could help in IP tech disputes, and also the various confidential safeguards that we can have that can be used in arbitration that can is particularly useful for tech disputes where trade secrets are involved. So I think we are it's a very we do have the very good tools in order for us to proceed with tech disputes here.
Thanks, Teresa. Sebastian, any comments?
Well, I think perhaps a key takeaway that I would want to highlight is that the parties really have the ability to choose a tribunal with particular expertise in relation to the area of IP or tech, and perhaps contrast that with the litigation approach, where you would tend to have specialist judges, but more with a broad specialty in the field. I think that's where IP arbitration is really attractive. You can really seek out the leading experts in a particular field and seek to appoint them to your tribunal.
Thanks a lot, Sebastian. And Nicholas, any closing remarks?
Well, I think most has been said. I just think when it comes to IP and tech disputes, that tool set we've talked about, confidentiality, speed, enforceability, and to the experience of the local and international community. I mean, Hong Kong is an international place, is really key, and obviously it's no secret that Hong Kong is particularly important for disputes with China. So I think that to keep in mind the special arrangements that Hong Kong has in place with the mainland that help in terms of interim measures and enforceability. That these are really the key takeaways, I think, for anyone who considers where to seat an IP dispute.
Thanks a lot, Nicholas. And I think that all of those comments are absolutely crucial when considering how you decide your IP dispute and where you decide your IP dispute, especially when you look at the fact that intellectual property is no longer simply a national regime. It's something which has to be dealt with and enforced globally, and especially in sort of a globalized commercial environment. You're no longer dealing with IP just simply within your national borders. And so, especially when you're looking at international arbitration, I think IP arbitration in Hong Kong, you've seen, all of our speakers talk about the various different tools and the various different options available for parties in respect of having their disputes resolved in Hong Kong and through HKIAC. So I think all that does is leave me to thank our panel, to thank Teresa, Sebastian, and Nicholas for their time and taking the time out of their very busy schedules to spend time here today at California Arbitration Week. And of course, to thank the organizers, to thank California Arbitration Week for granting us the slot to talk about a very important topic for us. If there are any questions, feel free to reach out to us. And otherwise, thank you very much for your time, and we hope you have a very good rest of the day. Thank you, and bye-bye.
Thank you.
Thank you.